It's 10:38 on January 28, 2025. The Blanco County Commissioners Court returns now to open session, having concluded its executive session with no action being taken. And perhaps, is there anything anyone wants to take up on item 16?
Yes, I'd like to make a motion to authorize the county judge to enter in the contract with outside counsel for litigation against the county.
Is there a second?
Second.
Commissioner Riley, discussion. All in favor, say aye.
Aye.
Opposed? Motion carries. Item 17, unless someone has any, I don't think there's any action to be taken. And that leaves us with item 20.
Make a motion, we adjourn.
Is there a second?
Second.
Commissioner Riley, discussion. All in favor, say aye.
Aye.
All opposed? Motion carries. We will now roll right into the public hearing. Excuse me, not a public hearing, a public workshop. Or just called a workshop. Regarding our subdivision regulations, and we're going to, with the commissioner's approval, we're going to skip over items 1 and 2, having already completed those earlier this morning, and we will have open discussion, but unlike you all, we haven't had any kind of a recess, and we'd like 5 minutes.
Thank you.
Ms. Waller, are you ready?
Yes, sir.
So it looks like everybody's ready. All back into order the workshop. And I guess start off with a couple of comments. We haven't done a workshop in a little while, so my recollection is the last time we did a workshop, we maybe had a sign-up sheet. I can't remember honestly how we did participation. So today, commissioners, unless you all want to have another idea, here's my proposal. We can either begin the conversation and incorporate people in, or we can ask people to share their comments with us now. Not particularly worried about time limits unless it just gets out of hand. But the normal 3 minutes under the Commissioner's Court rules for proceedings may or may not work out for a workshop. It doesn't seem like necessarily we have to do that unless somebody monopolizes this for half an hour. And I don't have a particular order. I was thinking about starting from the top and going through it, but I'm open to suggestions if you all have another way you want to do it.
I think that's a great idea. I think just starting from the very beginning and working our way through it, but if anybody has something that, before we move to the next section, please raise your hand or something, get with the court, that way we know, and we can address it as we go from the front to the back.
So at the very beginning, under the purpose of the rules, it says, where a literal interpretation of any section would create an undue economic hardship on the builder or developer, variances may be sought. And I mean, that's like right up front as part of our policy. I raised that to discuss later, so I just want to I don't have anything to say about that yet, other than for you to make a mental note, because there's another division that I wonder about. And my first one would be 101-100, and unless someone wants something sooner. Uh, 101-100, I just want to make the comment or the note that when it talks about if you own a tract of land that's outside the city limits and you divide it into two or more parcels, it's the definition of a subdivision or subdividing, and the words are directly from the statute. And I wanted to ask Ms. Ashby about taking statutory language, and I'm going from some prior experience and prior life, but taking statutory language and then putting it into a rule, whether that's a good idea or not. I never was all that fond of it because it's just repetition. But you care?
Well, if you put it in the regulations, then people only have to go one place to find everything. Understand what you're saying, Robert?
Yeah, I think that's a fair assessment. And I can move on unless somebody wants to talk about that. So I would go to 160 unless somebody has something else they want to talk about. It was 101-160, which is water availability. It says, that water availability regulations apply except when plating is exempt. And refers to all of the exceptions in 104. Is everybody still good with that? Okay, well, you're part of this discussion too, so.
Any of these subdivisions that are coming in that are over 10 acres, that is an argument. So we don't have to have a water availability study. But we are not protecting potential purchasers if there's even water out there.
So, but the way we have it in there is that if that's over 10 acres and that abuts a county road or a state highway, and then there's another thing that we need to take out of there, but, so,
Well, there's lots of exceptions, and that's one.
Yeah.
The 10-acre rule is one
Right.
exception. So, maybe a bad example, but Bird Ranch, most of those lots are in the 20+ acre range, I think, and it's old, it's pre-subdivision, but it's a lot of them. If that were to be created today, there'd be no water availability study required under 101, 160, right? How are you administering that today? Are we bluffing or?
I strongly suggest that they do it. I can't make them do it because they're, they put our page so-and-so on the book.
can I ask Ron? Ron, what's your opinion in this?
When you're talking 20, 10, 20, 30 acres, it's gonna be
Well,
hard.
so go back down to 6, because there's an exception for 6 acres.
6 acres.
Yeah, there's 6 acres. Yeah, there's an exception for 6 acres.
I think that's awfully close to 5 acres, and that seems to be a useful tool for these 5-acre tract subdivisions. Now, that being said, you get larger tracts, 10, 20, 30 acres, it's gonna be hard to design a water availability study because the wells are gonna be so far apart, but you're gonna put one well on each tract, or you're gonna drill 3 wells, and you're trying to, it's gonna be real difficult to design. I'm inclined to let that go, but 6 acres, anything less than 10 acres, I mean, it might be useful for the property owner, the developer, the neighboring property owners, for everybody would benefit from having a study done. But yes, there's some point where you get large enough acres, that it's not gonna probably be cost effective, and it wouldn't cover much.
Let me ask you, Rod, if it's 200 acres and they're 10-acre tracts, you're saying a water study wouldn't help that?
I think in that case it would, 10 acres or smaller. I mean, it's always hard when you start plugging in a number. You can plug in 10.5 acres or 11, you still got the same, quandary there. But I think that water availability studies serve a purpose. And we've already discussed, we've got something in the regs that address the cumulative effect, one subdivision to another. And I think that's for the smaller tract size, and I would go, 5, 10 acre tract, it seems to be useful.
So there's
10 acres is small enough, you could design a test that would work for that.
there's a series of exceptions, and one of them is Veterans Land Board Program. And it doesn't seem to reference any acreage at all as part of that. It just says if you're laying it out for veterans, and you're not doing some things like alleys and streets, but if you're laying it out for veterans, that's an exception to the plating requirements, which means the veterans would not get the benefit of a water study.
It could be, yes. And a long time ago,
Is that good?
I like to protect veterans. I'm one. And when I was looking at veterans landlord stuff years ago, it was a 10 acres or greater. And then they started having to drop that, I think, to 5 acres or greater for veterans land developments. So, water availability studies are useful. They're expensive, they're time consuming, but they're very useful. And at the same time, I can't see making somebody breaking a 1,000-acre ranch into 10 100-acre tracts even to do one. It's just, there comes a point, and it almost, it may be more of a political decision than a scientific decision, if you know what I mean. It's an awkward decision-making process.
So could we put it back just take that out of there where you keep your exception, where everything requires a water availability. And then in 205, we allow the groundwater district to give a letter of sufficient water as opposed to making them do a groundwater study on an instant like that.
Will the ground, in that scenario, water availability study requires punching wells, right?
Yes, it's required.
In your scenario, would the groundwater district avoid that, or would they do that without having to punch the wells?
I think that depending on the scenario, and I'm going to refer back to a tiny home subdivision or RV subdivision, because if you're looking at an RV that is so minimal, 2 acres making into RV lots, I can't drill a bunch of wells to do a groundwater study. So there's got to be a mechanism for the groundwater district to say, hey, that we believe utilizing either an existing well on the property or wells directly around it, that will say that there's the water is sufficient and available in this location, and they don't have to do, something to that nature.
Well, one thing that might help on that, Chris, is that most RV parks and little tiny house things, they often have enough pad sites and connections to qualify or be required to become a public water system as a non-community, non-transient public water system.
But I've also seen some that are small enough that they don't require that.
I know, I've seen
So, I mean, we need to have some sort of language in there that says, the groundwater district can give us a letter stating that there's sufficient water in this vicinity without making them do a full-blown groundwater availability study.
You'd probably have to work with the groundwater district on that. Basically, their rules are, let's say you got I can give you an example. I know a place where there's like 2 or 3 acres in the south end of the county. There's like 5 houses on it, and they're either relatives or workers, and they're all on one well. And that's perfectly legitimate. They're not a public water system. A private well owner, as long as he doesn't have a large pump in there, a large volume pump that stays in exempt well, he can water cows with it, give water to his ranch foreman, hunting camp, whatever. So I think that it's getting real awkward there. I see where you're trying to come at, but as far as right now, the groundwater district doesn't provide any certification like that to the county. If somebody wants to do that, it's just an exempt well, or it may be a permit well if they've got high volume pumping.
Can I ask you this? If you have back at the 20 tracts at 10 acres or larger, and right now we require on a water test a well per every 100 acres, is that correct?
Or thereof, that's correct.
You're saying we really don't need one if we have 10 plus acres, but yet we require one with our fire suppression out in front. So wouldn't you have at least one? Is there some sort of gain from having that one for fire suppression, but to also evaluate quality of water and possibly flow?
Yeah, you're starting to get to the idea that depending on the lot size, if you've got in your scenario 100 acres with 10-acre lots or whatever, a water study would be good because of everything you're mentioning, and it's still small enough acreage you could design a test. These wells have to be, in the best case, it'd be 200 or 300 yards apart, maybe at the most, because then you're going to get a response from the pumping well to the observation well, and that way you can run the calculations that the engineer or the geologist doing the study. If the wells are 2 miles apart on a huge, 50-acre subdivision, you're not going to get a response more than likely. So you're just pumping water out. You'll get a production capability, you know, if this well's making, 18 gallons a minute, or 10 gallons a minute, or 50 gallons a minute, but that's really all you're gonna get. So I like the idea of water availability studies, but, there needs to be either some well thought out, hierarchy or a sliding scale or something where you're right, you don't want to drill a couple of test wells on a 2 or 3 acre RV park or a tiny home subdivision. It's not even a subdivision. They're not really subdividing the land. They're renting pad space, just like an RV park. And you're right, it'd be nice to know the capability of some of these fire suppression things.
Well, we call them a subdivision.
It's classified as a subdivision.
Yeah, so.
RV lots are classified as a
Yeah,
subdivision.
I understand it, but
That's right.
it's hard because what if you've got an RV park that's on
No, I agree.
5 acres?
And I think we're on the same page.
Yeah.
We just gotta come up with something in 205 that can accommodate for those small tracks. But I agree with Connie, and let's take this language out of this section right here.
Well, before you jump to that, I'm wondering about, because I'm the one that brought it up, but instead of bringing it out, they're taking it out, maybe improving on it, because there are some exceptions that I think it makes sense for example, 197, transfer to an adjoining landowner. So all you're doing is cutting off, changing your fence line, cutting off a piece and selling it to the guy next door. I don't think that really needs a water study. So that exception makes sense to me, but I'm wondering if maybe we should be more specific in the language instead of saying, except when planning is exempt, if we say, except in these instances, and we list the exceptions that we're talking about.
And you don't want somebody doing a domino effect where he slices off 5 acres for this friend, and the next one he gets another 5 acres for this one a year later or 6 months later.
But it's an adjoining owner, that's the key.
So anyway, there's something, I see your point, yeah. And maybe the veterans landlord thing, you mentioned that.
There's a couple more, but that can, the idea is we want to look at that and see which ones make sense and which ones do not.
Well, I've got some comments on 205, but I wasn't prepared for this discussion, so I'm kind of winging it here, guys.
If you want to hold them, we got a ways to get there, so. My next concern is 104, 190, unless you all have something sooner.
I have something in 103.
Okay.
So in 103, going from a bond, construction bond to a maintenance bond, I would like to make a formal sign-off page where the fire marshal signs off on it, Doucette signs off on it, and the commissioner signs off of it to bring it to court to say, everything that's in the subdivision rules meet my area of expertise. So like if the fire marshal doesn't sign off on it because there's not an FDC valve on the fire suppression system, then it's not gonna go from construction bond to maintenance bond. Because that's our teeth. The construction bond is our teeth. So that's kind of what my thought is.
And is that, so the sentence that,
I don't know exactly, I'm just trying to.
the sentence that I think encapsulates a lot of your argument is bond remains in effect until improvements, blah, 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 have been approved by the commissioner's court and the bond has been released by order of the commissioner's court. And you're wanting to add some steps.
Yeah, I just want to, maybe it's a checklist or something that we can do, a signature page that, Ron signs off and says all the drainage ditch and all the compaction tests were passed, or, because Ron's not going to be here forever, so it might be the next guy so at least it's a checks and balances kind of thing.
Do you still want to leave the commissioner's court in there?
Yes.
So then maybe it's just in order for the commissioner's court to consider it.
Right.
These steps.
Yeah, that's gonna be in our packet that it's signed off by all those people and, that will allow us to go from one
It
to
would
the
be
other.
it'd be at the time that you're releasing the construction bonds, that would be in the same conversation.
Correct. It will be in your court packet when you say, we're gonna go from this to this. I'm gonna have the signature saying that everybody signed off on it, said that they agree.
Sounds pretty reasonable.
Yeah. Yep, there you
Have you got anything before 104, 190?
No, sir.
So I don't really want to change anything. I just want to make sure that I'm in conformity with your all's understanding of it, your all's. Where it's talking about no permit's going to be issued for a septic system until you complete your subdivision plan. And I started thinking about, well, if it's now, bear with me, but if it's just a plot of land out there in the county somewhere that somebody buys and it's not even part of a subdivision, and it's not platted, and somebody builds a house and wants to have subdivision, the permit's gonna go out there and they're gonna apply for a permit, I think. The permit's gonna go out there and watch the system. And ultimately certify it, we hope. And that has nothing, well, let me say it this way. It doesn't have anything to do with subdivisions, but it's this. Do we agree that the way you withhold it, it's not about whether or not they comply with subdivision regulations, it's whether or not they comply with uniform standard septic concepts or designs.
Well, you have to figure where you have the teeth to stop it if it's done wrong. And the only time at that point right there is through your septic tank permit.
But is that your understanding or the way you think it applies is that when there are no subdivision regulations to be talking about that if somebody's trying to, I don't know, run a line out to the pasture and Kermit has a problem with that, but that's how we address that.
Just through the
Separate,
permit.
well, not, yeah, with the permit and really, I changed the example. If you're running the raw sewage line, then it's gonna be a health and safety issue. But do you all agree that it's not, I'm just making sure that I understand that we don't, that we have other means when it's not a subdivision.
Well, we require design and all of that. So, I mean, we've got that in our subdivision regulations already, but there has to be somebody follow up on it all the way to, to the cover of it when they're covering the tank and the laterals. There has to be somebody there for a final inspection, but it doesn't necessarily have to be part of the subdivision, right? Somebody building the house on a piece of property.
Is this,
So the only other thing to do is open that floodplain.
Wouldn't that be part of the initial permit on the design?
Well, it depends who we were just talking about. I thought this was like a kind of a unplatted development.
Well,
Yes,
yeah.
unplatted development.
Yeah.
Well, I wouldn't call it a development, it's just a,
Well, whatever. I mean, a resident or whatever. I mean, they have no idea. They stick it down there and get, big rain events. Well, I never seen water this high.
but isn't that part of Kermit's responsibility
Yes.
to recognize that?
Yeah,
So nobody's perfect.
Yeah, I mean, that's part of the problem is, the county, there is not a whole lot of floodplain study to determine where that's at. Is the biggest problem.
Have you looked at those FEMA maps?
Yes,
I was looking at them last night and they're not,
yeah, there's very little in Blanco County that's mapped.
I know some counties are getting their own studies. They're hiring people to do their own studies so that they can do it. I know we're not in that position, but I still think the study's there when you get, when in the permit stage, you'll go out and look at the terrain and don't they do perk tests? They dig and check for the soil density and the type of soil and all of that. If we need to add something to that to make it even more stringent, I don't know. I'm sure it can be done.
104, 100. I just wanted to emphasize that all of you all always talk about an affidavit of land location, and and I just blindly accept it, but, that's not what we actually have. What we have is an affidavit of land location and exception. In other words, the person that's executing that affidavit is identifying and relying on a particular exception for why they even are doing an affidavit. And I think, I just wanted to point out that that's a pretty critical part. That's what the whole thing is about, is the exception. My next one would be I think it's 104, 120. Is that the family division?
Yeah.
Do you have something, sir?
No,
It says property cannot be, it's, after you do this family division, property cannot be sold to any person not related to the grantor within third degree of consanguinity or affinity. And there's no time,